Hi, folks. A couple of quick bites at the GDPR. Those of you who are deep eyeball into GDPR, move on. Those of you who are trying to figure out whether GDPR applies to you or some of the very other specific items, I'm going to do a couple of quick bites just to respond to some of the misconceptions that I sometimes hear coming up. Hopefully some of you who have more to add will chime in. So let me talk about one thing that I keep hearing, and I think it comes from people who don't have a legal background or a good background of the different cases that the courts in Europe have interpreted over the years. Yes, GDPR is new, but the courts have been dealing with issues like jurisdiction and some of the basic legal interpretations of language that is used in the GDPR. And so it's useful to have some of that context. So here's one thing that I hear coming up all the time. I'm in the US. I don't do business in Europe. I'm a hospital. I'm a business, and somebody from Europe, a tourist, walks in, signs up, gets admitted to my hospital, signs up for a service. Am I subject to the GDPR? And the answer is almost certainly not, other than in some very, very limited circumstances. The GDPR does not give European citizens an inalienable right to data protection that they carry around the world. You go to Antarctica, the penguins cannot invade your privacy, or you will be subject to violation of European law. Not the way international law works. For a business to be subject to the law in a particular country, you have to have some expectation that you will be covered by the law in that country. Otherwise, you might be in violation of some Chinese law. Right now, today, they may have passed a law saying when you see a Chinese person, you need to shake the hand in a special way, right? I mean, it doesn't make any sense. And international law has long recognized that there's got to be some nexus between the activity. And there are debates on the outer boundaries. And the GDPR does have some long arms, so we'll talk about that. But just because I'm a European citizen or a European resident, I don't carry those rights with me. You are subject and protected by US laws, of which I think some of our European colleagues don't give us enough respect. So if you're a kid, covered by health law, covered by credit, covered by insurance, covered by banking, and yes, not covered by a lot of other general marketing areas, except for spam and except for things that are deceptive or unfair. So plenty of US laws. Certainly the European system goes further, but it does not come along with you. When are you, if you are a US business, a website, a university, a hospital, subject to that long arm? If you are offering goods or services, it doesn't mean selling something, but you've got to be offering goods or services, or if you're monitoring behavior within the EU, right? So you might be in the US, but you might be somehow tracking users in Europe in some very extensive way. That probably doesn't mean that they visited your US site, but perhaps you've got ad tech, you've got code that is being used to track Europeans in Europe. So the courts have in the past taken a look at what types of things might capture you in that. You might offer something in euros that is not guaranteed to capture you, but it is possible. You might have a Spanish or French version of your site aimed at people in that area. You might ship there. Certainly, if you buy ads on a search engine that are targeted, it's going to be a case-specific set of activity. Do you have a European domain? The court. The High Court in Europe, the CJEU, has looked at this concept of offering goods and services. When will it be directed to EU member states? They looked at it in a different context, but again, this is going to be very relevant. They looked at it under what is known as the Brussels I regulation. It's 44/2001 EC that talks about jurisdiction in civil and commercial matters. In that case, the CJEU said that an intention to target EU customers may be illustrated by, one, patent evidence. It's just blatant. Paying money to a search engine to facilitate access by those within a member state, or other factors, sometimes maybe in combination with each other, the international nature of the relevant activity, right? So maybe hey, French tourists come visit Times Square. You might have a special telephone number, accessible from a particular European country with an international code. You might have a .de or .eu domain showing that you're doing business in Germany. You might have an itinerary that says, hey, we're on a tour, and it's going to go from a particular member state to the place where the service is provided. You might talk about, and again, I'm quoting from the case, you can take a look at it. You might talk about international clientele that is composed of customers domiciled in various member states, right? Again, you're indicating. So if I'm a higher ed institution and I have a program abroad with European students, that is obvious. The court in that case was very clear that this wasn't exhaustive, and it is a case-by-case basis. So there's got to be a nexus, or there's got to be monitoring, tracking individuals online to create a profile, for instance, particularly, maybe tailoring ads or specifically marketing. If you are one of the organizations that I have mentioned, and you don't have an establishment in Europe, right? If you have an establishment in Europe, we'll switch to that in a second, then you're clearly covered, right? We'll talk about what does it mean. People used to talk about setting cookies or having servers. There's a different standard here, which we'll talk about, the Weltimo standard, again, where the Court of Justice of the European Union, the CJEU, gave us some guidance around what is an establishment. But if you're one of the people who is not established, you don't have any people, but you are subject to this long arm jurisdiction, you might be snickering here and saying, well, what are they going to do about it? How are they going to get me? I'm here. I don't have any people. Well, you are obligated under the GDPR to appoint a representative so that you can be sued. Otherwise, you are doing business illegally, at least in violation of data protection law, and anybody doing business with you over there might be cautious and probably should, if I was advising them, if I was advising a European company or a US company that is in Europe, because they're established, they've got people, they've got sales, they're providing services back to you, they may say to you, do you have a representative here? Because that's what data protection law requires. And if you're going to warrant that you're complying with local data protection law, in addition to following the rules, which we might be on the hook for if we're facilitating this, if we're operating as a processor or a controller that is working with you, we might ask you to represent that you're following the rules. So who is your representative here? There are not a lot of companies providing representative services. There are a lot of people who would like to be your data protection officer, but your representative is potentially on the hook. They may or may not be personally on the hook. There are a couple of folks providing this, but not a lot. If I'm an app and I'm in one of the app stores, seems like checking off, make me available in the French App Store or the French Play Store, there's pretty good evidence that you're doing business in that country. And so you may need to figure out how to appoint a representative. I don't know, we'll try to figure out whether this is an area where we can be helpful, but it may be a challenge. Okay, maybe you are actually established in Europe, in which case there is no question that you are subject to data protection in Europe. So what does it mean to be established? It means that you need to be processing personal data in the context of the activities of such an establishment. So let's assume I am established. I got all kinds of people and resources, not a question. But I'm doing work for a US company in anywhere in the world, perhaps, there still has to be some nexus that the work I'm doing is in the context of the activity. So there may be some circumstances where a European company is doing something abroad. The data processing is happening abroad, but it's not in the context of the activities. But if it is in the context of the activities of their establishment, then hey, Americans, you're protected, whether or not the data processing happens in Europe or not. So that means whatever, when Max Schrems files all these lawsuits against US companies under his new not-for-profit, arguing that they're not complying with GDPR, well, you could go to European websites sitting here in the US and sign up for various services. And if they do not respect the GDPR rules in handling your data, they are established in Europe. If the work they're doing for you is in the context of this establishment, they're subject to GDPR. So, make your access request, make sure your rights are protected. So that's a nice thing. Okay, but are you established? Here's the standard under the 2015 Weltimo case, Weltimo versus NAIH. Here, the court said that establishment is a broad and flexible phrase that should not hinge on legal form. You are established if you have any real and effective activity, even a minimal one, through stable arrangements. That could be, a single representative is enough. So Weltimo was established in Hungary because they had a Hungarian language website that advertised Hungarian properties. So it was considered to be directed at that member state. They had a local agent who didn't work for them, but who was an agent who helped collect debt and was a representative in court proceedings. And they had a Hungarian postal address and a bank account, even though they were in Slovakia, right? But they didn't have employees or servers or some of the things that you might think typically was the case. So if you're an organization with a EU sales office that sells ads or targets EU residents, you're likely to be subject to GDPR because the associated processing of this personal data is considered to be inextricably linked and carried out in the context of those activities. Okay, so there's more. The UK ICO guide is really useful here. Bird and Bird has a really good guide that talks about the jurisdiction section in lots of detail. But just high level, I want to sort of myth bust. European, everywhere in the world, you're not automatically protected by European law. You are if the companies you're doing business with are established in Europe, even if they're maybe physically elsewhere in the world, but they've got sales or they've got other connections the way the Weltimo case describes. Or if you're dealing with a US business that is holding itself out in some way so that they should expect that they're subject to European data protection law, monitoring in some large scale people in Europe, tracking you in Europe, or doing a number of things on their site or in their service that indicate, and that doesn't mean simply taking your email address and saying, you're in Europe, but I intend to attract Europeans in my activities. And that could be a combination of language, could be in combination with advertising, obviously a special program for Europeans. So typical hospital, unless you're doing something to encourage Europeans to come for some special services, somebody simply walking in, you're not putting yourself in the position of GDPR. Anyway, hopefully that's useful, and look forward to talking to you all soon.